Greetings to everyone. It's a great pleasure to welcome you all to the seminar series of Climate Change and Law Laboratory of Kadir University Law Faculty. Today, we host a very special guest, Professor Dr. Douglas Kysar. Welcome, Professor Kysar.
Thank you.
We are deeply grateful to you for your participation into our seminar series. And before we start, I would like to introduce you to our audience. Professor Douglas Kysar is a professor of law at Yale Law School and faculty coordinator of the Law, Ethics, and Animals program. His teaching and research areas include torts, animal law, environmental law, climate change, products liability, and risk regulation. He was previously on the faculty at Cornell Law School. He received his Bachelor of Art from Indiana University in 1995 and his Juris Doctor from Harvard Law School in 1998. Following law school, he clerked for the Honorable William Young of the United States District Court for the District of Massachusetts. Professor Kysar, welcome again. I would like to thank you for accepting our invitation. And here I would like to leave the floor to you.
Thank you so much for that lovely introduction, and thank you for the invitation to spend time with you and to participate in your wonderful speaker series. I just want to start by saying how deeply sorry I am for the tragedy and the loss that your country has suffered in the earthquakes. And I also want to apologize because my talk, the time we spend together, it won't really be a relief from disaster and tragedy, because my talk is about climate change. And much of what I will talk about is how the disasters that climate change contributes to raise difficult challenges for litigation and for the tort law system. I'm going to start sharing my screen now so that we can see my slides. Hopefully those look okay. When I was asked to send in a title for this talk, I originally thought about sending in this. The Cambridge English Dictionary defines a whodunit as a story about a crime and the attempt to discover who committed it. And my talk was going to examine climate change litigation through the lens of a whodunit novel, showing how different strands of litigation can be seen as efforts to develop compelling narratives about who bears primary responsibility for the climate crisis. But on reflection, I decided that the talk was both too dark with its reference to the end of the world, and also too flip with its characterization of gravely serious climate advocacy efforts as being analogous to writing mystery novels. So instead, I've gone with this much more sober title. In the talk, I will explore implications of the field of climate attribution science for tort law adjudication. Climate attribution science can be defined broadly as the scientific study and estimation of causal responsibility for the drivers and the impacts of climate change. For my purposes as a tort lawyer, there are three related but distinct questions that arise within the field of climate attribution. First is the question of warming attribution. How much of observed and projected climate warming is attributable to greenhouse gas emissions associated with human activities, separated out from other drivers of planetary change? Second is impact and extreme event attribution. To what extent has climate change caused or increased the likelihood of various impacts on social and natural systems, including extreme events like hurricanes, wildfires, droughts, and floods? Finally, source attribution, which is probably most pertinent for tort law. What portion of climate change and its impacts can be attributed to the choices and actions of specific individuals, companies, nations, or other identifiable human sources? Scientists are beginning to improve their capacity to answer all these questions with specificity and confidence, and their work is beginning to affect how the public and policymakers perceive the urgency of the climate crisis around the world. As I'll argue in this talk, these developments also hold significant implications for climate change litigation and the field of tort law. Over time, the reality of climate change and its harms will influence judicial practice at a fundamental level. To some extent, it already has. Take the category of warming attribution as an example. The Intergovernmental Panel on Climate Change, through its 5th and 6th assessment reports on the state of climate science, has laid to rest any lingering uncertainty regarding the role of human activities in causing harmful climate change and the need for a dramatic shift of course to avoid severe planetary disruption. The role of warming attribution science in climate litigation is straightforward, but highly significant. Whenever the empirical reality of human-caused climate change is at issue within a lawsuit, such as when climate impacts are asserted to establish standing, or when the adequacy of an environmental impact statement is being challenged because it fails to consider greenhouse gas emissions, courts are then put in a position to affirm the epistemic legitimacy of climate science. A notable example, an early example, occurred in the very second sentence of the United States Supreme Court majority opinion in a 2000 case called Massachusetts versus EPA. Then Justice Stevens emphasized that warming attribution is accepted by respected scientists. Because the legitimacy of courts is premised on independence and responsiveness to reason and evidence, this pointed phrasing, respected scientists, reached beyond the specific parties and the narrow question presented before the court to try to affect larger societal and political discourses. Given that there is a continuing challenge of effectively communicating the reality and the significance of climate science to lay people, securing these independent judicial affirmations of climate science fundamentals remains a significant motivating factor behind many climate change lawsuits. The effects of the other two categories of climate science, attribution science, are more speculative and will be the primary focus of my talk. I'll start with source attribution and then turn to impact and extreme event attribution because together they tell a story about the limits and future potential of litigation against a backdrop of widespread and often severe climate-related suffering. In the United States, the most high-profile climate change tort suits today seek to hold major fossil fuel companies responsible for present and anticipated costs relating to climate change. Brought on behalf of governmental plaintiffs like cities and states, as well as private plaintiffs, such as a fishing industry trade group, these lawsuits allege public nuisance and related tort law claims under state law, arguing that the fossil fuel industry has known for decades that its products contribute to global climate change, while simultaneously foiling government action through misrepresentation, deceit, and aggressive lobbying tactics. To prevail on a public nuisance claim, plaintiffs must show that defendants unreasonably interfered with a right common to the general public via instrumentalities controlled by the defendants. A variety of doctrinal questions arise from this attempt to configure climate change as a public nuisance, including the question of whether a stable climate system is a right common to the general public. In that sense, the private climate law climate suits can be seen to overlap with the normative questions that are raised by constitutional and human rights climate change suits. Here, though, I want to focus on the question whether fossil fuel defendants control the relevant instrumentalities causing climate change, because that question directly implicates the source attribution field of study. The current wave of what we call carbon majors tort actions in the United States follows an earlier wave of suits that were filed unsuccessfully in the 2000s. The more recent filings seek to capitalize on factual developments in two key areas that are of potential relevance to industry liability. First, a series of academic and journalistic investigations uncovered a substantial amount of evidence regarding the extent of the industry's long-standing internal knowledge of climate science and the grave threats that are posed by greenhouse gas emissions. Second, the field of source attribution has developed such that plaintiffs can now portray fossil fuel defendants as being responsible for human-caused warming, slow onset impacts like ocean acidification, even specific climate-related events, all with a precision that was previously unavailable. These carbon majors lawsuits call to mind litigation against the tobacco industry, which similarly sought to shift societal perceptions of a deeply entrenched and powerful industry by focusing on the alleged callousness and deceit of those who profit from it. Whether this narrative of industry culpability will be persuasive to courts depends somewhat on whether plaintiffs will reach the discovery and trial phases of litigation. To date, the suits have been mired in disputes over venue and other preliminary matters. The defendants in these cases have uniformly sought to remove to U.S. federal courts, despite the fact that the companies are being sued exclusively under state law. Defendants anticipate a friendlier reception in federal court, in part because of very stringent requirements on standing and justiciability, but also because of a perception that federal judges are more likely to view state tort law as an inappropriate body of law to address climate change. One case that appears very much to confirm that perception is City of New York versus Chevron. In this case, a federal appellate court addressed state tort law claims brought by the City of New York against 5 multinational oil companies. The city was seeking damages for harms and expenses suffered due to climate change. The panel first held that global warming presents a uniquely federal international problem of national concern that could only be addressed by federal rather than state common law. The panel then held that federal common law itself is displaced by the U.S. Clean Air Act statute, even when a litigant merely pursues a claim for damages rather than for injunctive relief. Central to the court's reasoning was a concern that the plaintiff had ulterior policy motives in bringing the suit. The court thought that the City of New York was trying to achieve regulatory goals in court that it had failed to achieve in the political branches. Whether or not that concern was warranted, the twin holdings of the court had the effect of precluding all judge-made law, federal or state, to challenge activities which generate greenhouse gas emissions. A similar withholding of judicial power occurred in the constitutional public law case of Juliana versus United States. In this case, youth plaintiffs alleged that the United States government has violated the plaintiff's constitutional rights by promoting fossil fuel production, despite decades of official awareness of the catastrophic dangers posed by climate change. In Juliana, a federal appeals court panel held the plaintiffs lacked standing to bring their claims because the court held their alleged injuries are not redressable through judicial relief. In order to reach that conclusion, the panel seemed to think that redressability required judges to somehow solve climate change, rather than merely to provide the kind of remedies that the plaintiffs requested. Strikingly, the panel even discounted the importance of declaratory relief, reasoning that judicial acknowledgement of a constitutional rights violation would only benefit the plaintiffs psychologically, which the panel felt was not a strong enough interest to support standing. The panel seemed to adopt the same skepticism toward climate change litigation that we saw in the City of New York versus Chevron case. The panel described plaintiffs' claim as a demand that judges devise, quote, a comprehensive scheme to decrease fossil fuel emissions and combat climate change. A very different judicial attitude was on display in the first state court opinion in the United States to address a motion to dismiss in one of the carbon majors suits. Hawaii trial judge Jeffrey Crabtree, who interestingly serves as a designated environmental court judge in Hawaii, Judge Crabtree handily waved away the fossil fuel defendants' arguments that the case somehow required a suspension of ordinary common law processes. Particularly in the context of tort law, judicial hesitation to engage with the merits of a climate change claim seems unwarranted. Tort law has ample doctrinal machinery with which to manage even an unfathomably vast and politically vexing issue like climate change. For instance, assuming hypothetically one or more of the climate damages suits ever reach the merits, a critical contested element would concern how to assign and apportion liability in light of the vast number of actors who might be considered to have caused climate change. This is where the field of source attribution comes in. A number of research groups are dedicating time and attention to determining which entities are responsible for which percentages of historical and ongoing greenhouse gas emissions. A groundbreaking study in 2014 concluded that nearly 2/3 of the carbon dioxide emitted since the 1750s can be traced to the 90 largest fossil fuel and cement producers in the world, most of which still operate today. Though they have not yet been named as defendants in most climate liability suits, the heavily concentrated industrial animal agriculture industry also has been subjected to source attribution analysis. Researchers estimate that the 5 largest global meat and dairy companies collectively are responsible for more emissions than either Exxon, Shell, or BP. Source attribution studies, they take anthropogenic climate change, the mother of all collective action problems, and they try to reduce it from a problem caused by several billion past and present human individuals to one that's driven by a few dozen companies. As such, they try to make climate change appear more amenable to traditional tort law adjudication. So if courts were persuaded by these studies, they could utilize the study's calculations as a basis for apportioning damages for climate-caused harms. The approach would be analytically similar to what we call market share apportionment in the US, which has been utilized in products liability, groundwater contamination, and other scenarios involving large numbers of defendants. Rather than relying on market share as the basis for allocations, courts simply would utilize the metric of historic and continuing responsibility for emissions. But will courts find the source attribution characterization of climate responsibility to be persuasive? A critical matter of judgment concerns whether fossil fuel defendants should be held accountable for emissions that occur throughout the entirety of their company value chain, or instead only for emissions that are directly under their control. Within the field of corporate climate reporting, emissions from owned or controlled sources like oil and gas equipment are considered to be Scope 1 emissions. Emissions attributable to purchased electricity, heating and cooling, and other energy services consumed by that reporting company are considered Scope 2 emissions. All other indirect emissions occurring along a company's value chain are considered Scope 3 emissions, including releases that occur when an end user burns coal to run their power plant or gas to drive their car. For fossil fuel companies, Scope 3 emissions are significant because the vast majority of the total related emissions fall into this category. The question then arises whether those emissions should be attributed to fossil fuel defendants rather than to their customers or to the government that authorized and supported their production. Some published opinions in the US climate litigation space appear to recognize this attribution puzzle. In City of New York versus Chevron, for instance, the panel noted pointedly, every single person who uses gas and electricity, whether in traveling by bus, cab, Uber, or jitney, contributes to global warming. The court seemed to be asking why the City of New York singled out 5 multinational oil companies for responsibility when all humans have been participating in the fossil fuel economy that those companies enable. The difficulty for plaintiffs here is that all humans are embedded in systems that give rise to greenhouse gas emissions. And as the youth plaintiffs in Juliana have powerfully argued in their lawsuit, governments at the highest levels have promoted and supported those systems despite knowing for decades of the catastrophic risks they entail. Why are the carbon majors more causally responsible for climate change than the governments that authorize and subsidize their activities, the manufacturers of vehicles, equipment, and other products that utilize fossil fuels, or the consumers who benefit from them? Plaintiffs in these lawsuits have a couple of different responses to this difficulty. First, as I mentioned earlier, plaintiffs aim to present evidence of fraudulent and deceptive practices by the fossil fuel defendants in order to lessen the perceived causal responsibility of end users and lawmakers. Just as smokers might be seen as less responsible for the health harms of tobacco use in light of industry efforts to manipulate public awareness and government policy, plaintiffs hope to portray Scope 3 emissions as the natural and proximate effect of manipulative behavior by the fossil fuel industry. Second, plaintiffs want to take a more pragmatic turn and draw on existing examples in the environmental context which have succeeded by taking a liability-based approach to the question of how to marshal capital toward underfunded environmental needs. Most notably in the US, we have a statutory liability scheme known as Superfund, which requires parties responsible for hazardous waste contamination to pay for cleanup costs and associated damages. Superfund casts a very wide net when it defines responsible parties. It includes the people and entities who are in control of a relevant facility, even if they weren't in control at the time of the waste dumping. It includes the people and entities who were in control at the time of the waste release. It includes people and entities who arranged for the transport and the disposal of the hazardous waste. And it includes parties who choose the location for waste disposal. So the aim of the statute is to look broadly through a hazardous materials history and value chain in order to identify a deep pocket that can help remediate a dangerously contaminated site. Notably, although Superfund was established by statute, lawmakers drew heavily from common law principles when they crafted the liability scheme. This analogy to Superfund offers an alternative way for courts to understand the kind of relief that's being sought by climate change plaintiffs. The plaintiffs are not seeking to use the judicial process to achieve a greenhouse gas regulatory regime. Instead, they're asking for compensation for expenses that stem from the impacts of climate and the need to adapt to those impacts. Just as in the Superfund context, the question they're asking is simply, how do we marshal the necessary funds? From the plaintiff's perspective, the fossil fuel defendants' causal role in contributing to the harms marks them as a potentially responsible party who should help shoulder the massive public costs of climate change. Whether courts will find that characterization persuasive is an open question. The returns to date suggest a great deal of skepticism, at least among US federal judges. As these cases slowly make their way back to state courts, plaintiffs remain hopeful that at least some judges will agree with Judge Crabtree that the actions can be seen as a good old-fashioned tort suit, despite the extraordinary factual backdrop of climate change. So in the remainder of this talk, I want to take that viewpoint a step further. And I want to ask, how will tort suits that really are old-fashioned change as the impacts of climate change become ever more pronounced and pervasive? That is, putting aside the trillion-dollar question of who bears liability for causing climate change, how will the reality and severity of climate affect more garden variety tort claims of wrongful behavior? I believe as the state of climate attribution science grows in certainty, coverage, and detail, it will become increasingly likely that in order to avoid being deemed wrongful under tort law, actors will need to take account of climate change and its impacts in their decisions and actions. A central premise of tort law is that actors hold a duty of care to guard against the reasonably foreseeable risks of their conduct. Climate change will expand the scope of risks that are reasonably to be foreseen. For example, in the wake of a deadly collapse of a 12-story condominium building near Miami Beach, Florida, investigators and regulators have focused on the potential role of climate change in making that disaster more likely to happen. Sea level rise, saltwater intrusion, flooding, and extreme weather combine to stress the structural integrity of coastal buildings. Under standard principles of tort liability, property owners owe a duty of care to residents and other guests that includes guarding against hazardous conditions the owner could discover through reasonably careful investigation. We haven't seen case law develop on this point yet in the United States, but I would argue that that careful investigation at present includes consideration of how the foreseeable impacts of climate will threaten the safety of properties. In addition to property owner liability, you can easily imagine tort law evolving to include consideration of climate-related risks as a routine aspect of exercising professional judgment. A lawsuit currently pending in Massachusetts against Exxon challenges the company not for its direct contributions to climate change, but instead for failing to comply with good engineering practices. The plaintiff, an environmental nonprofit, argues that Exxon has failed to consider climate impacts like stormwater, extreme event storm surge in its stormwater pollution prevention plans, especially for the company's petroleum storage and distribution terminals, despite having taken steps to secure against climate-related risks other more valuable equipment like offshore drilling equipment. Because of this internal dual standard within Exxon's company, the lawsuit argues that the Massachusetts terminal is vulnerable to climate-related flooding and therefore toxic chemical releases that will harm surrounding poor minority neighborhoods. We can think of this as a failure to adapt claim. These claims could also begin to be made under tort law against engineers, architects, planners, others whose professional expertise concerns the built environment. In 2014, for instance, an Illinois insurance company filed lawsuits against several cities, arguing they failed to consider climate-related heavy precipitation events in their stormwater management plans, leading to excessive flooding, which caused the company to have to pay out increased amounts to their policyholders. It should not be a defense in any action like that the defendant relied on building codes or floodplain maps or other official records that have not been updated to take account of the present and projected impacts of climate change. The inadequacy of those existing records is now widely understood. Lawyers, accountants, investment managers, other financial professionals might also begin to incur liability for failing to incorporate climate impacts into their relevant areas of expertise. An intriguing example comes from Australia, where a worker sued his pension fund, arguing that the fund's managers failed to provide information about and prudently guard against threats posed by climate change to the value of the fund's investments. The fund settled the lawsuit by adopting a new climate risk disclosure practice, by committing to a net zero emissions target for the company's portfolio by 2050, and by agreeing in a statement that, quote, climate change is a material, direct, and current financial risk to the fund. As regulators and institutional investors around the world move toward a regime of more formalized and extensive climate change risk disclosure obligations, the role of litigation in policing those disclosures will become significant. Companies, and in some cases their professional advisors, may face liability to investors, consumers, and others who rely on inadequate or misleading climate disclosures. Property liability and professional malpractice are just two examples of what I think will be a broader phenomenon. The manner in which courts assess all tort duties will be impacted by the fact that we live in an era of elevated risk due to climate change. The US Judge Learned Hand famously conceptualized the duty of care and negligence law as a function of three variables. In many areas of relevance to tort law, climate is raising both the probability of an adverse event occurring and the magnitude of harm caused if the event does occur. For instance, consider the problem of wildfires, which around the world have increased significantly, both in scale and duration, due in large part to climate-related impacts like heat, drought, and lightning increases. As a result, both the P and the L associated with activities that might lead to fire outbreaks have increased, leading to a larger set of Bs or burdens that defendants arguably must take in order to avoid having their conduct be deemed negligence. Indeed, it's even possible to imagine climate impacts shifting the risk level associated with an activity so significantly that the activity comes to be seen as abnormally dangerous and therefore appropriately subjected to a standard of strict liability rather than negligence. Returning to the wildfire example, we might ask what kinds of activities might come to be seen as abnormally dangerous in the future, given the significant fire risk they pose even when reasonable care is undertaken. Fireworks displays, for instance, at least in the United States, are not subjected to strict liability because courts assume they can be undertaken safely through reasonable care, and therefore a negligence standard is adequate to control them. But will that assumption change in the future for states that are heavily threatened by wildfires? What about campfires? What about cigarette smoking, which may have been in common usage at one point in those areas, but will become increasingly shunned as an unnecessary fire hazard in the coming climate century? The point is not to answer these questions at present, but instead to begin to locate them on the horizon and to consider them as examples of a wider dawning of climate change awareness that will impact tort law in coming decades. Whatever may become of the high-profile lawsuits that seek to hold fossil fuel companies or governments responsible for causing climate change, the sheer pervasiveness and magnitude of impacts from climate will ensure that the tort system must grapple with how to adapt individual duties of care in a world of collective recklessness. Of particular challenge will be catastrophic events. On the one hand, climate modeling is becoming ever more precise and rapid, allowing scientists to conclude extreme event attribution analyses within days of a potentially climate-related event's occurrence. For instance, when severe flooding struck Western Europe in the summer of 2021, scientists working in the World Weather Attribution Network were able to quickly estimate that human climate change made the event as much as 9 times more likely to have happened. More dramatically, the extreme heat events in Siberia during 2020 and the Pacific Northwest of the US and Canada were found by scientists to have been virtually impossible without the influence of human-caused climate change. Given tort law's preponderance of the evidence causation standard, which asks whether a challenged conduct was more likely than not to have caused a harm, these attribution analyses are almost tailor-made to support legal attribution of an extreme event to human-caused climate change. On the other hand, the analyses leave in place the source attribution problem that we discussed earlier. They only identify humanity as the causal agent behind an extreme climate-related event, rather than some legally accountable subgroup of humanity. In tort law, at least in the US, even when an individual defendant is identifiable as the causal culprit behind an event of mass loss, tort law historically has been reluctant to hold defendants responsible for the outsized consequences of those shortcomings. A prominent example in the US is the case called Strauss versus Bell Realty, which arose from a massive electricity blackout that was suffered by New York City in the summer of 1977. The blackout was due to the fault of Consolidated Edison, the electric utility. Among the many harmed was a 77-year-old person named Julius Strauss, who ran out of water in his apartment building because the water was supplied by an electric pump that could not run during the blackout. He fell and sustained severe injuries as he attempted to descend an unlit stairwell to fetch water from the basement of his building. He sued his landlord and the utility. Earlier litigation had established that the utility was grossly negligent, so the court in Strauss only had to decide the extent of the utility's liability. Nevertheless, the lawsuit seemed to rattle the New York High Court. In a remarkably candid opinion, the court dismissed the complaint explicitly on what it called, quote, public policy grounds. In the face of what it called liability, which could obviously be enormous, the court made a decision which it said was not strictly governed by tort or contract law principles. What exactly did the judges fear? A dissenting judge pointed out that Con Edison, the utility, could have easily distributed the costs among its consumers in the form of higher rates. In response, the majority of judges alluded only vaguely to what they called the societal consequences of rampant liability. Turnabout is fair play, as the saying goes, and Con Edison received its due nearly a quarter century later, when disaster again struck New York City. Seeking to recover damages for an electricity substation, which was destroyed after the 7 World Trade Center building collapsed during the 9/11 tragedy, Con Edison alleged the building had been negligently designed because the applicable safety codes required that such structures should be able to withstand uncontrolled burning without collapsing. In that case, the New York City Fire Department made a decision to stop trying to fight the fire. This was not the Twin Towers, but this was an adjacent building. And the fire department decided to stop fighting because they were losing so many firefighters during the tragedy. The building code required that such buildings be able to withstand uncontrolled burning, irrespective of what caused the fire. But the court fixated on the fact that the particular fires at issue in 9/11 were caused by an unprecedented terrorist attack. The court likened the event to, quote, a fire triggered by a nuclear attack on Lower Manhattan, clearly implying that ordinary rules of tort law would be suspended in the event of a nuclear attack. Technically, the court said that Con Edison's claim failed for lacking causation. That reasoning, though, was unpersuasive, as a dissenting judge clearly demonstrated. What truly drove the majority's decision was a sense that tort law was simply overwhelmed by what the court called the unprecedented etiology and severity of the cataclysm that engulfed Lower Manhattan on September 11th, 2001. Judicial hesitation in the face of massive, unimaginable events is understandable, but climate change raises the prospect of catastrophic events that become routinized and therefore in need of being incorporated into the ordinary operations of law. 18 of the 20 largest wildfires recorded in California history have happened in the most recent 2 decades, with 8 happening in the most recent 2 years. Each of the previous 7 years have established records for ocean temperature, a critical reason why hurricanes are increasing in intensity and impact. In 2017, Hurricane Harvey dropped as much as 60 inches of rain on Houston, causing damage to 100,000 homes and $125 billion of total losses. In 2021, 50 people drowned when the remnants of a hurricane overwhelmed stormwater drainage systems in the northeast of the United States. According to our National Weather Administration, the US in 2021 experienced 20 separate billion-dollar climate and weather disasters, second only in number to the record-setting year of 2020. Reflecting on the historical trends, the agency noted, it is concerning that 2021 was another year in a series of years where we had a high frequency, a high cost, and a large diversity of extreme events that affect people's lives and livelihoods. It is concerning because it hints that the extremely high activity of recent years is becoming the new normal. Negligence attends these tragedies, even if the role of climate change seems to overwhelm individual human agency. In Houston, for instance, city planners relied on rainfall records that were 2 decades old prior to Hurricane Harvey, despite clear awareness that urban flooding events had been rising for years. If tort law continues to demur in the face of catastrophe, even as these events become agonizingly familiar, then the common law will begin to cede some of its normative power. Consider as a final example a case that arose from the devastating Hurricane Katrina of 2005. In a case called Barasich versus Columbia Gulf Transmission, residents of southern Louisiana sought damages under state law for personal injury and property loss they claimed was caused by oil drilling and pipeline construction. The complaint alleged that the defendant corporations had destroyed millions of acres of marshland through their dredging and drilling operations. That destroyed a crucial protective barrier of the Gulf against storm surge. The plaintiffs in this case did not attempt to link the ferocity of the hurricane or the defendant's oil and gas production to climate change. Instead, they were relying on the direct conduct of the defendants in destroying the protective marshland. They also relied on Louisiana's capacious concept of negligence. Despite this carefully circumscribed theory of liability, the trial judge granted the defendant's motion to dismiss. The court rejected the idea that the case was non-justiciable as a political question, but the court held, nevertheless, the plaintiffs failed to state a claim. The court offered several reasons, but they all centered on issues of proximity. The court narrowly construed the idea that property, trespass, and nuisance liability lies only among neighbors. The court viewed the plaintiffs as distant strangers to the fossil fuel defendants, even though the activities of those defendants had powerfully shaped the entire coastal environment of the Gulf of Mexico. In fixing the orbit of duty for purposes of negligence, the court emphasized that defendants were physically and proximately remote from the plaintiffs. In a revealing conclusion, the court accepted the plaintiff's basic theory of causation, but recoiled from the implications, inviting the plaintiffs instead to refile with a less ambitious lawsuit. In other words, the lawsuit seemed to fail not because it contravened traditional tort principles, but because it took those principles to their logical conclusion. The plaintiffs reached a point where the weight of the case moved it from the domain of tort to politics, from adjudication to regulation, where the scale of harm overwhelmed the perceived capacities of the common law. Judicial failure to engage tort law's norm-articulating capacity in the face of climate catastrophe is, at least in my view, regrettable, because the climate crisis is driven in substantial part by an absence of shared norms of responsibility. Put plainly, the mother of all collective action problems stems from the assumption that no law, policy, or principle prevents the dumping of waste into the sky. Now, as the sky has begun striking back, we face a similar normative vacuum when addressing responsibility for the suffering induced by climate disasters. Confronted by that vacuum, tort law could play a role in the development and enunciation of norms of responsibility. The role need not be decisive, and legislatures can always choose to revise or repeal common law pronouncements within constitutional boundaries. But active judicial engagement with the challenge of developing norms of responsibility in the climate change era, in my view, is much more desirable than the alternative of judges simply staying on the sidelines. Even in the most optimistic scenario of climate mitigation, we are destined for at least the next 3 decades, and likely much, much longer, to have continued warming with accompanying mostly negative impacts. Harms will be pervasive and often devastating. Attribution science, with its unequivocal linking of human activities to climate change and climate change to harmful impacts, eventually will settle into lay and judicial mindsets. The ultimate question of who bears responsibility for putting humanity into this plight will remain contested and unlikely to be met with judicial resolution. But our duties of care and regard for one another in an era of routine, predictable, and extreme harm will necessarily evolve. Whether by choice or by necessity, we will become accustomed to judging care in a reckless world. Thank you for your patience and attention during that long talk. I would love to engage in conversation with you.
Thank you so much, Professor Kysar'ı, for this absolutely fascinating lecture. Thank you very much for sharing us your thoughts and the picture about the climate change and the liability issues. You have really well highlighted the problem of determination of which entities are responsible and for which part of the damages. It was really, really interesting, and we have learned a lot from this lecture. Now we can start questions and discussions session and have the questions of our audience.
And we kindly invite our participants to raise their hands to ask questions or write their questions to chat box in order to make us read for them. I guess Ms. Bigetekin has a question or comment. Please, Ms. Bigetekin.
Thank you very much, Professor. It was very interesting for us to listen this climate crisis topic to listening from you. Thank you very much. I just want to ask, since it is very hard to attribute an exact proportion of responsibility to firms, how do you think about the mitigation of damages as a starting point? So do you think that can we claim damages from firms, like because of their lack of action after a certain point where this climate change has become so obvious and they didn't take any necessary action to stop it? Mm-hmm. Thank you.
Thank you, Tuğçe, for your question. You know, it's very interesting. Obviously, my talk focused on climate litigation in the United States, which is where my expertise is, but I'm somewhat aware of climate litigation around the world. And in most other jurisdictions, the plaintiffs are framing their lawsuits not about responsibility for past behavior, but rather ongoing duties to kind of change behavior going forward. And those, to me, seem much more politically palatable to the judges. It's a lot easier to say to Shell, now you need to change your business operations to start being compliant with the Paris Agreement and divesting yourself of fossil fuels. It's a lot easier to say that than it is to say to Shell, you have to pay hundreds of billions of dollars to all the victims of climate-related harms. If you're a judge, the former seems a lot less volatile than the latter. That said, I mean, part of what's driving climate litigation in the United States and the kind of backward-looking financial responsibility lens that's being applied in a lot of these lawsuits, a lot of what's driving it is the reality that the government entities, the lower governments, the states and the cities and the counties, these are going to be the people left holding the financial bag. They're going to San Francisco has to move its airport because of sea level rise. That's hundreds of millions of dollars. And so they're looking around and they're thinking, well, these fossil fuel companies continue to make record profits. I don't know if you've seen in the news, but all the major multinational fossil fuel companies in the past year have been announcing record profits to the tune of $20 to $30 billion for the largest private companies. That's money that is going to be needed. It's going to be needed to, I mean, think about the devastation in Pakistan last year when a third of the country was underwater. There's financial need there to recover and to kind of compensate. And we've got to figure out where that money's coming from. That's the impulse that's driving these suits. And the suits, they're trying to kind of file in as many jurisdictions as they possibly can with the thought that it just takes one. It takes one lawsuit to kind of break through, one brave judge to kind of say, this is actually amenable to good old-fashioned tort adjudication. And that might start a trend, which we've seen internationally. The court in the Netherlands, which held the Dutch government responsible for an inadequate climate plan, started a trend. And we saw multiple other national courts around the world adopt similar approaches. Thank you for your question.
Thank you very much.
And we have another question from Antoine, and he wanted us to ask whether do you think ongoing efforts to obtain advisory opinions from international courts might affect the domestic climate litigation landscape, or whether international law developments are very much removed from domestic private litigation developments?
Thank you for that question, and it's good to see you. Yes, I think the answer is absolutely yes. I'm very excited. For those who aren't aware, there is a very active and seemingly poised for success campaign going on in the United Nations at the moment. It's being led by the small Pacific Island state of Vanuatu, but it's a coalition now of over 100 co-sponsoring nations. Under the UN system, the General Assembly can request an advisory opinion from the International Court of Justice. And the opinion that's going to be requested is asking what responsibilities states have under international law, including customary international law, not to substantially contribute to climate-related harm within other states' jurisdictions. And then second, this is the quite remarkable part, they're also going to ask the ICJ to opine on whether states bear essentially financial or legal liability for harms that are caused by a violation of the first principle, the first obligation. And it's always possible that the ICJ might try to duck this advisory opinion. Historically, they have not when they've been requested by the GA out of comedy and respect for another part of the UN system. They've answered the questions. But the second question is so politically volatile that one could imagine ICJ judges trying to avoid. But nevertheless, I think it's potentially a huge development. It's advisory, it's the ICJ, so it won't have kind of direct, immediate behavioral impact. But that pronouncement, that crystallization of a norm of international responsibility, it will trickle down and it will influence national courts in their own kind of constitutional and human rights decision-making. It will affect very much the negotiations within the UNFCCC. I think it's hard to overstate the potential normative power of that campaign. I'm particularly, admiring of the campaign because of the way it originated. So years ago, I had the great honor of co-teaching a class with Ambassador Stuart Beck, who was the ambassador for the tiny, small island Pacific nation of Palau. And Ambassador Beck was a very, very creative and visionary diplomat who was deeply concerned with the environment, led a number of initiatives via Palau to protect the marine environment, because it's obviously so important for those Pacific small island states, but then became increasingly concerned about climate. And if we don't address and solve the climate problem, then all the other environmental victories are put in jeopardy. And so Ambassador Beck, this is back in around 2012, was pushing the General Assembly for an ICJ advisory opinion. That campaign did not succeed because of immense pressure placed upon Palau by the United States. But we wrote a big report about it. And as I'm told, some law students at the University of the South Pacific were reading the report and became inspired and turned to the Vanuatu government and said, let's bring this back to life. Let's push this campaign. And this time it's succeeding. So I'm keeping my fingers crossed. I think we'll have a vote soon at the GA, but it's really quite remarkable. Remarkable also to think of a group of law students like potentially having such an enormous impact. Really inspiring.
Thank you for your answer, Professor. Any other questions or comments from our audience? I guess Mr. Abanus has a question or comment.
Yeah, I have a question. Thank you for organizing this event and thank you for all the informations. Sorry, I'm not able to turn off my camera. I hope you are familiar with the case brought by a Peruvian farmer against RWE before German courts. So how do you evaluate that case in terms of attribution science? Do you think it has a good stance? Do you have any forecasts about it, or other than its results, do you see any other importances related to that case? Yeah, that's my question. Thank you.
Yes, and thank you so much for raising that case. It's a really fascinating and potentially, I think, quite significant case. For those who aren't familiar with it, this is a lawsuit being brought by a farmer from Peru against RWE, which is, I think, the largest utility in Germany. And essentially, the farmer and his village are suffering climate-related impacts due to the loss of snowpack and other adverse changes to the environment that are making it hard to farm and hard to have access to drinking water. And so he's suing for compensation, financial compensation. And he specifically requested only proportionate damages, proportionate to RWE's share of overall global greenhouse gas emissions, which is tiny, which is like a 0.0 something percent. And I think the math works out that it's essentially about $20,000 US dollars that he's asking for. And you might think, well, how could $20,000 matter to one of the largest electricity utilities in the world? Well, it would matter in the following sense. If there's success, it would be because a court accepted these two propositions. One, that a plaintiff from anywhere in the world, Peru, can come to Germany and sue a German company in German courts, and that defendant has to answer. That would be a startling holding. And then second, that allocating financial responsibility by source attribution, by the percentage of greenhouse gas emissions an actor is responsible for, is a kind of cognizable judicial method of showing causation and awarding damages. And so I just have to believe that if that case succeeds, even though the dollar verdict will only be about $20,000, the shock that it will send throughout corporate boardrooms throughout the world will be tremendous. Because you just have to think of all the plaintiffs from Pakistan who could come to Germany and sue for last year's flooding. It's just quite remarkable to think about. So I'm definitely keeping a close eye on that case. It's quite fascinating.
Thanks, Professor, again. And any other questions or comments? I guess okay. We received another question from chat box. It is from Mr. Yildirim. The question is whether the political question doctrine is still a valid point of discussion with respect to climate change cases 15 years after the Kivalina versus ExxonMobil Corporation case. Thank you very much in advance.
Yes, it's absolutely a very live and active debate. And, I think many court systems around the world have some version of this doctrine. The basic idea is that there's some cases that courts consider not amenable to judicial resolution and are kind of more appropriately addressed to the, quote, political branches, to legislatures and executive branches. In the United States, the doctrine doesn't have a strong basis in the text of our Constitution. The courts have kind of made it up as a way to protect, in their view, to protect their institutional legitimacy. I guess the fear is that if you're taking on a problem that feels like it belongs in one of the other branches, then that will be perceived as judicial overreach, and it might threaten the kind of integrity and legitimacy of the court in the long run. And it's definitely been invoked against climate change because climate change does seem to implicate vast, very complicated, important policy questions. The problem that I have with it when it's applied to tort law cases is that in tort law, the judges, like the plaintiff is making a claim that has certain elements, duty, breach, causation, harm, and those elements themselves are where you ask the question, did the defendant owe a duty to this actor to prevent this reasonably foreseeable risk? So it's the tort duty elements themselves that answer the kind of question of whether it's amenable to judicial resolution. So you don't need to layer on political question doctrine on top of traditional tort law principles, because traditional tort law principles are already designed to kind of answer the same basic normative question. It's similar to the way applying standing requirements to tort law claims becomes a little bit redundant and I think unnecessary. Standing is asking, did the plaintiff suffer an injury, that's traced to the alleged failure of the defendant, that is redressable through judicial means. Well, that doctrine was pulled from common law tort principles and adapted to the context of plaintiffs challenging government administrative actions. You don't need to then reapply it back on top of tort law because those doctrines were already within the normative structure of tort law. But that said, the judges aren't listening to me. All around the world, you're seeing, at least in some places, this idea that climate is kind of a political question that just is too hot for judges to handle. That idea gets traction. Interestingly, it seems to get the most traction in the Anglo common law jurisdictions like Australia, Canada, New Zealand, the United States, and less traction in civil law jurisdictions.
Thank you for your answer. And again, I would like to ask whether our audience has any other questions. I don't have any other questions in the chat box, and I see no raised hands, so I may give the floor to Professor Açık.
Thank you, Ece. Yes, I would like to thank our audience for their questions and to Professor Kysar for his insightful answers. Now, unfortunately, we have come to the end of time allocated to us for this event. I would like to thank everyone and especially to Professor Kysar for participating in our event and sharing his thoughts, sharing his knowledge for us. Thank you so much. And I hope everyone enjoyed today's lecture. We wish you stick with us on our next event. And here I would like to give the floor to Professor Kysar once again to have his closing words before we finish.
Well, I just want to thank you so much again for including me within this very important series, and thank all of the audience members who came to listen. I think these are extremely important issues. And as you can tell, I think courts need to be part of the conversation. And I hope I've persuaded you. But thank you so much for being here.
Definitely. You have inspired us. I can say that. Thank you again. Thank you, everyone, and goodbye for now. I wish you all a wonderful time in the rest of the day.
Thank you.
Bye.